When dealing with solid waste management in Indian country, there are at least 5 issues you need to take into consideration. The first being the tribe's codes, ordinances, and overall governance structure. The second issue is the environment that you're dealing with. The third is the people and culture, including traditional cultural values. The fourth is economic development. This would include what is currently existing within the tribe, as well as future economic development pursuits. Central to all of these issues is tribal sovereignty. Sovereignty is defined as the right of self-governance. It is the right of any entity to make its own laws and to be governed by them. It's important to understand the difference between sovereignty and sovereign immunity. Sovereign immunity is the right to be free from suit, the right not to be sued in court. A sovereign cannot be sued because the sovereign assets are the assets of the community as a whole. Now, when we're talking about tribal sovereignty and tribal sovereign status, there's 2 trains of thought. There's first inherent tribal sovereign authority. This is the inherent sovereignty that tribes have by virtue of being nations. This inherent sovereignty is subject to tribal powers only. However, when we're speaking of environmental statutes, what often comes into play is the legal sovereign status of tribes. This legal sovereign status is what's defined within the U.S. government's federal Indian law. Now, tribes possess a legal sovereign status because of treaty making between the tribes and the U.S., as well as other foreign powers. This legal sovereign status of tribes is subject to the plenary power of Congress, as well as the interpretation of law by federal courts, and in some cases state powers were delegated by Congress. What's important to understand is tribal sovereignty was initially recognized by the U.S. as a result of having entered into treaties with tribes. The U.S. and the nations that predate the U.S., for example, England, Spain, etc., recognized the inherent tribal sovereignty, or the inherent sovereignty of tribes as nations, then entered into treaties with those tribes, creating a legal sovereign status, because the U.S. only negotiates treaties with sovereign entities. Now, the U.S. may expand or contract its recognition of tribal sovereign authority. Tribal sovereignty, either inherent or legal sovereignty, that right to make your own laws and to be governed by them, is only meaningful if there's a system for disputes concerning those laws, if the community being governed by the sovereign authority has a system of dealing with any disputes that may arise. In modern tribal governance, in order to determine the laws of the tribe, the jurisdictional authority, and other matters of governance, you have to look at the tribal constitution. Not all tribes have a constitution, but they do have a governing body of laws. So there's the tribal constitution, there's the legislative process and record of that tribe, and that would include the codes of laws, ordinances, as well as resolutions of the tribal council if the tribe has one. There's also the consideration of what type of tribal law enforcement exists, whether the tribe has tribal courts and what matters those courts hear, what type of adjudicatory jurisdiction those tribal courts utilize, as well as the consistency within the community of using those laws. And consistency establishes a community standard. Community standards are created by a consistent enforcement and use of tribal laws. Above all else, within solid waste management, you need to look at consultation, cooperation, and collaboration. When talking about sovereignty and governance within Indian country, federal Indian law often comes into place. There are 3 primary cases which are the starting point for talking about tribal governance and tribal sovereignty. Those cases are considered the Marshall Trilogy. The first of those cases is the Johnson v. McIntosh case of 1829. This case is where the doctrine of discovery was first applied. In the Johnson v. McIntosh case, it was a case involving 2 non-Indians. One of the parties had purchased land directly from an Indian tribe. The other party had been given a land grant by the U.S. The case before the court was who had the proper title to the same piece of land. In analyzing this case, the court came up with a theory which became known as the doctrine of discovery, which meant that a Christian nation could come to a land, claim it in the name of that Christian nation, and that property, that title to the land, would be that of the Christian nation. And only that Christian nation would have the right to extinguish title to that land for possession. The U.S. gained that possessionary right from England, Spain, the Christian nations that came before it. So under the doctrine of discovery, the U.S. has exclusive right to extinguish original tribal right of possession, either by purchase, treaties, and other methods, or conquest. That meant that under the doctrine of discovery, the tribes were only left with the right to use and occupy the land. So the party in Johnson v. McIntosh who had purchased the land from the tribe only purchased the right to use and occupy the land. The right of possession was held by the U.S., and so the party who had purchased the land from the U.S. was the one who had the ultimate right to possess that land. This theory cleared up any doubts with respect to land claims that may come after the Johnson v. McIntosh case. Cherokee Nation v. Georgia, 1831, the second of the Marshall Trilogy cases. The state of Georgia gained land when it entered the Union, and it soon discovered that a large portion of Georgia territories were actually Cherokee Nation territories, in which the state had no authority. So the state of Georgia attempted to apply state law over the Cherokee Nation in order to annihilate the Cherokees as a political society. The Cherokee Nation immediately filed suit under the U.S. Constitution's foreign nation provision, which allows a foreign nation to go directly to the Supreme Court to hear a matter. This provision is often used by states filing matters against each other. The U.S. Supreme Court held that the Cherokee Nation was not a foreign nation under the Constitution, so they weren't allowed to go directly to the Supreme Court. But what the court did hold is that the Cherokee Nation was a domestic dependent nation, which meant that they had a higher level of sovereignty than the state, and that the state could not pass laws to annihilate the Cherokee Nation as a political society. This domestic dependent nation standing still holds today, and it provides that the federal government has authority over tribal nations, but tribal nations are sovereign, and state laws do not apply within those lands unless the federal government gives those states permission to have laws within tribal lands. The domestic dependent nation status also provides that tribes cannot enter into treaties with foreign powers. Tribes are only permitted to enter into treaties with the U.S. government. The final of the Marshall Trilogy cases is Worcester v. Georgia, which was heard in 1832. In this case, 2 missionaries were sentenced to 4 years of hard labor by the state of Georgia for residing in Cherokee without having a license and having taken an oath to support Georgia Constitution and laws. After the loss in Cherokee Nation v. Georgia, Georgia passed laws that required anyone crossing through Georgia territories to obtain a license as well as swear an oath to the laws of Georgia. These missionaries passed through Georgia territory but went straight to Cherokee Nation and were residing in Cherokee Nation at the time. This case was an act of Georgia trying to exercise authority within Cherokee Nation territories. One of the missionaries, Worcester, challenged the jurisdiction of Georgia to institute their laws within the Cherokee Nation. The U.S. Supreme Court held that Indian nations were distinct independent political communities, and state laws had no effect within tribal lands. It is said, but hasn't been validated, whether President Jackson purportedly told Marshall that he had made his decision, but Jackson was not going to enforce it. It was later seen that the missionaries were released when South Carolina tried to leave the Union, and Jackson allowed the missionaries to be let go. So with these 3 Marshall Trilogy cases, you get 3 trains of thought which still exist today. 1, that the possession of land within the U.S. is held by the U.S. government, and that tribes only retain the right to use and occupy the land. That 2, tribes are domestic dependent nations. And 3, that we start from the point where states have no authority within tribal lands because tribes are distinct, independent political communities. These 3 cases together are what make the trust relationship. The trust relationship is based on laws of trust. Now, a legal trust usually comes to an end. The trust relationship between the U.S. government and tribes will only end when tribes cease to exist, legally or otherwise. In this trust relationship, the trustee are all the federal branches of the government who hold title to tribal lands. The rest of the trust, the body of the trust, are the lands and resources that are held by the U.S. government for the benefit of tribes and their members. And that makes the beneficiaries tribes and their members.